Hello, good evening. Welcome to this edition of Good Evening Ghana. Thank you very much for joining us. Tonight we have an interesting legal discussion that you can't miss. When we're coming into the studio, many people ask me whether I was going to talk about matters of petroleum. There's a brewing story at the bulk oil storage and transport, which Joy FM have been leading on. But no, that's not our discussion tonight. Tonight we want to bring you sufficient education and settle some of the matters in your mind about last week's event. Last week, there were three Supreme Court decisions that were handed down, many of them of broad significance to many Ghanaians. The first one, I'm not sure which was the first one, but there were three of them. One of those is the Gitmo 2, which became an election issue and over which President Mahama held a press conference. If you are hearing it for the first time, two of the detainees in America's Guantanamo Bay were brought to Ghana under a contract or an agreement between the government of the United States and the government of Ghana for them to stay and live in Ghana to supposedly reform. Many Ghanaians were against the decision, and one of us went to the Supreme Court to test the merit of the decision by the government. It turned out that the Supreme Court said the decision had no merit to the extent that Parliament was not consulted in the matter and that there was no parliamentary consensus, approval, or knowledge of this matter, that President Mahama was wrong in doing so. The court, in its consequential orders, decided that the matter goes to Parliament for Parliament to have a look at it. So that's one of the cases that we'll be looking at. The other one is of broad significance to young people who want to become lawyers. Over the last 10 years, there has been a growing appetite of many Ghanaians, and it does happen in democracies. Many young people want to be lawyers so they can have a say in the democratic process. Not that non-lawyers cannot have a say, but they want to have a say in a very big way, either in court or one way or the other. So many young people want to become lawyers. For that reason, there's been pressure on the institutions of legal training. Many private ones have developed, apart from the public ones, University of Ghana, University of Science and Technology, and lately the University of Cape Coast. Other private institutions have developed training law graduates. When these graduates are trained, they will have to be called to the bar to become members of the Ghana Bar Association. The General Legal Council then decides on how these matters are arranged. There's a law school that used to sit in Makola in Accra, where these lawyers were trained to become members of the Ghana Bar Association and to have audience in the courts of Ghana. Over the few years, because of the pressure, this law institution, the law school, has been duplicated in three other places. One more in Accra and another one in Kumasi. It appears that it's still insufficient for the number of graduates coming out with law degrees. And so the General Legal Council instituted an examination procedure for people to take this exam and then get into the law school. If you fail the exam, you will not be able to get into the law school. You will not be able to train to get audience in Ghanaian courts, and you will not be a barrister called to the bar to practice in Ghana. Now, people went to court, an individual went to court to challenge this procedure about examination. What did the court hold? The court held that the examination process was unconstitutional, and that next year the process cannot hold in 2018. That those who were to take the exam in 2017 September should, however, proceed to take the exam. But the unconstitutionality was pronounced, and it was delayed until next year. It said also that the General Legal Council should seek a parliamentary process that will develop a legislative instrument to guide the procedure. If they were to do that, then the procedure will become sacrosanct and it will be in accordance with law. Any other manner, the procedure cannot be in accordance with law. These were the words of the court. And it turned out to be quite controversial. Questions were asked, how can the court pronounce an unconstitutionality and yet postpone the effect of the unconstitutionality? That if a matter is unconstitutional, it is unconstitutional, and that's where it ends. So we'll be looking at these matters. Also, another significant ruling for the business community, the investment community, the National Investment Bank was embroiled in some controversy with people who believed that the bank owed them a certain amount of money, over 100 million United States dollars. They had sued the bank in the High Court and in the Court of Appeal and had received favorable judgments from these courts. However, the Supreme Court ruled again last week that the money that was to be paid by the National Investment Bank ought not really to be paid, because the people who brought the action, they don't have capacity to do so before the Supreme Court of Ghana. This also raised significant eyebrows and is very, very significant, crucial, even critical for the business of banking in Ghana. We'll be looking at this very sensitive matter as well. So three cases on the table tonight: the Gitmo case, the law school matter, and the NIB matter. Lawyer Kwame Kufu is in the studio. He's here in his sartorial elegance, and we hope that he has come with his erudite presence as well to give us information about what the law says or what the law ought to be in each of these matters. All of these judgments that we talked about were part of the first outings of Her Ladyship, the new Chief Justice Sophia Akufu, who was sworn in by President Akufo-Addo last weekend, set up immediately in court to lead the Supreme Court panel in all of these three judgments. So we welcome Sophia Akufu. It looks like she will be doing a lot from the bench, in addition to doing from administration, as she has become the head administrator of the judiciary. She'll be doing quite a bit from the bench. By the kind courtesy of the Judicial Service, we have obtained photographs of all the old Chief Justices who were mentioned by President Akufo-Addo when he swore in the new Chief Justice. Let's have a look at that event and a few things that President Akufo-Addo said when he swore in Sophia Akufu, who has now led the Supreme Court to deliver the three judgments that we'll be talking about tonight. So here is the event last week at the banquet hall of the State House. Here is President Akufo-Addo.
She'll be walking in the footsteps of the 12 previous occupants of the office, whose names read like a veritable who's who of Ghana's legal profession. Aku Kosa, Julius Sarkodie Addo, Edward Akufo-Addo, E.A. Lankwe Bannerman, Samuel Azukra, Fred Apalu, E.N.P. Soa, Philip Archer, Isaac Aban, Edward Redu, George Aqua, and Georgina Ward. I have no doubt, however, that in her we have a worthy successor to Chief Justice Wood and the others who have gone before her.
So that was President Akufo-Addo naming them, the justices of the Supreme Court. We have to say that there were foreign justices of the Supreme Court, and the first one was Aku Kosa, who was the Ghanaian. The first Ghanaian was Aku Kosa. Most likely, that's the reason why President Akufo-Addo began with that. But the first ever Chief Justice in 1876, appointed in 1876 to 1878, was Sir David Patrick Chambers. He was the first Chief Justice. Here is Aku Kosa, who became the 13th Chief Justice of the Gold Coast, Ghana, and he was the first African to so become. Aku Kosa, the learned, very, very well respected judge. The next one we have something to say about, significant, is also Edward Akufo-Addo. Edward Akufo-Addo was Chief Justice and also became ceremonial president in the arrangement of the Second Republic. Adom Akufo-Addo, Chief Justice, who became, this is Justice Sarkodie. No, we don't have much to say about Justice Sarkodie. He was also one of the Chief Justices. But this is Edward Akufo-Addo, who became Chief Justice and later ceremonial president. That's what we have to say about him. Do we have videos of him as ceremonial president? If we don't, we just move on. You are watching Good Evening Ghana is live. Now that's the video of the swearing-in ceremony of Edward Akufo-Addo, who was Chief Justice and later became president. That's him in the tie, taking the oath of office in front of the Supreme Court judges, just where he had sat before, and he became president in the arrangements of the Second Republic, where Ghana had a ceremonial president. Edward Akufo-Addo, of course, widely known, a notorious fact that he is the father of President Nana Addo Dankwa Akufo-Addo. So that's Edward in a close shot of it. This photograph from the Associated Press. Prime Minister Buzia in your shot there. I'm not sure who this is, but this will be the Chief Justice of the day, most likely Azukrab. Okay, so we move on. After Akufo-Addo, there's also Justice Archer, Justice Aban, I should say, about whom we can say something. Justice Aban was an apostle for democracy, and he was single-handedly responsible for the democratic events that occurred in the 1970s in Ghana. Justice Aban was the electoral commissioner during that period. Justice Aban was the electoral commissioner during that period, and it was who decided that the referendum that had been conducted by the military government at the time, whether Ghanaians wanted a military rule or whether Ghanaians wanted civilian rule, the yes and no referendum, which apparently was being manipulated by the military junta of the day so that it would be said that Ghanaians wanted joint civilian and military rule, UNIGOV. It was Justice Aban on your screen now who, as the Electoral Commissioner, against the wishes of the military junta, who had guns on him, decided to declare the results in favor of Ghanaians having voted no to military and civilian rule together at the same time. Of course, Justice Aban had to escape the country to run for his life, but he did a yeoman's job in establishing a pillar of democracy in Ghana, in creating the judiciary as an independent pillar of democracy in Ghana. As Electoral Commissioner during the Champon era, we pay tribute to Justice Aban in that regard. Very, very strong man. Later, he became Chief Justice. And also there was Philip Archer, who became Chief Justice during the 80s. By the time we arrived at constitutional rule, Philip Archer is remembered for the 31st December case, a case that had gone to court. The MPP was challenging the celebration of 31st December as a public holiday, and the court ruled in favor of the applicant, the New Patriotic Party, and declared that 31st December cannot be a public holiday. Justice Archer was with the minority view of the day, and he famously said that the courts must give judgment that they can carry out, because if the court said it was not a holiday and the soldiers wanted to celebrate without armored vehicles, as he put it, the court will not be able to see its judgment to its logical conclusion. However, Philip Archer's view in the matter was defeated, and 31st December was outlawed as a public holiday. But Philip Archer was one of the finest judges. He wrote a lot of poetry in his judgments. Very, very beautiful writer of his very famous judgments. Philip Archer, also a great judge. And then there's also Georgina Wood, who is just exiting, but who we can say has done a lot for the judiciary. Georgina Wood is responsible for the many developments that we see now in the judiciary, in the automation of the court, in creating new court buildings, bringing credibility to the judiciary, and the sheer decorum with which Georgina Wood conducted herself publicly was to the admiration of many people, Justice Georgina Theodore Wood. However, for lawyers, law students, and legal luminaries, there was slight disappointment when Georgina Wood did not name herself as one of the panel members for the famous election petition in which the MPP was challenging for the first time in the history of Ghana results of a presidential election. It was widely expected that the learned Chief Justice will sit as a panel leader and lead the panel to deliver the judgment and to indicate clearly to the nation where the position of the law was. But alas, Georgina Wood did not sit, and it was rather Justice Atuguba that he nominated and paneled to be the leader of the court in that regard. So people still wonder what was Georgina Wood's legal opinion in that matter. How would she have voted in that matter? It is something that she's left Ghanaians with, that perhaps she should have filled the gap and settled it at that time to be a member of the panel. It's expected that when big cases come before the court, the Chief Justice will sit and render the judgment, lead the court, and create her leadership as well, not just in administrative, but also in terms of the letter that is delivered by the judiciary as far as the law is concerned. It was expected that Georgina Wood will sit. However, the election petition happened nonetheless, and Justice Atuguba delivered the judgment of the court. We have heard President Akufo-Addo for the first time give a reaction to that outcome of the case when he inaugurated Sophia Akuffo. But let's hear the judgment first, and then we'll come to what we have seen to be President Akufo-Addo's first reaction as President of Ghana. Here's the judgment.
Bafubone JSC grants the claim of voting without biometric verification, cancels the votes involved, and orders a rerun of the areas affected. In the circumstances, the overall effect is that the first respondent was validly elected, and the petition is therefore dismissed. Our various judgments, for the sake of convenience, are handed over to the Registrar of this court. We highly commend.
That was Justice Atuguba delivering the famous judgment in the election petition. After giving a mathematical rendition of what may have happened, he goes and completes. Knowing that people perhaps could not follow everything that he said, the judge was kind to us and told us that in the circumstances, the overall effect of everything that he had been saying, which was quite difficult to follow on that occasion, even as journalists reporting from the press box, it was completely difficult to follow. He said in the circumstances, the overall effect is that the first respondent, President Mahama, was validly elected. So that brought to an end the election petition and the the process of governance continued and there was another election. But during the, as we looked at the videos during the inauguration of Justice Sophia Akuffo, the new Chief Justice, it appeared that President Akufo-Addo had commented or is commenting on the outcome of this Supreme Court matter for the first time since he became president. Here is what he said.
Thus far, the judiciary can be said generally to have discharged in the Fourth Republic its duties creditably and responsibly. Even though I was on the wrong end of the petition, of the decision in the famous election petition of 2013. A favorable decision of the day could have meant perhaps that this was my second term in office rather than the beginning of my mandate. The attachment of the Ghanaian people to the rule of law made it possible for us in the New Patriotic Party to entrust our fate to the highest court in the land in the aftermath of the disputed elections of 2012.
So that for us is the first comment of President Akufo-Addo about the outcome of the election petition. And President Akufo-Addo proceeded to talk about the conduct of judges, the way in which he would like to see judges conduct their cases, and the way in which he would like to see judges deliver their outcome. Let us go and hear what he said. When we finish with that, we will add an addendum to what he said, a quotation from Lord Patrick Devlin. After that, we'll take a break. We'll do the archive, take a break, and the distinguished Kwame Akuffo, senior lawyer, senior practitioner of law at the Ghana Bar Association, will join us in the studio. So we'll look at the Supreme Court effects of the Supreme Court outcomes in the three cases that was mentioned. Here is Akufo-Addo seemingly worried about the process of the justice delivery at the courts in Ghana. Here's what he said.
It is vitally important that we have judges who are honest, possess integrity, and a sound knowledge of the law. The situation where judges prefer judgments on the basis of decisions from lower courts and cite them as law is not acceptable. And even as so, when judges cite no authority at all for their rulings and give orders without reasons. Our judges must be learned, know their case law, and ensure that their judgments are properly motivated. This is the only way the rule of precedent, what we the lawyers call the principle of stare decisis, can operate, which according to the well-known common law doctrine, quote, promotes the even-handed, predictable and consistent development of legal principles, fosters reliance on judicial decisions, and contributes to the actual and perceived integrity of the judicial process, unquote.
That was President Akufo-Addo in what appeared to be his first reaction to the outcome of the election petition. Just to add an addendum to what he said, we found a quotation. This quotation we have actually used on Good Evening Ghana during our extensive coverage of that election petition. Is by Lord Patrick Devlin. And just to remind our friends who like the law, our law students, friends, and our lawyers who seem to like this quotation so much, here is Lord Patrick Devlin. And this quotation was cited by Justice Aikins in one of the Supreme Court cases, a case in which J.H. Mensah was worried about the way in which ministers were going to be ministers without being vetted. It's a case entitled J.H. Mensah versus the Attorney General. It was heard in 1997 at the Supreme Court. Here is what Aikins said in quoting Lord Patrick Devlin. Here's the quotation so that we can all read together. It goes as follows. Can we skip up the live off there? Okay, there you go. Lord Patrick Devlin says, if a judge leaves the law and makes his own decision, even if in the substance they are just, he loses the protection of the law and sacrifices the appearance of impartiality, which is given by adherence to the law. He expresses himself personally to the dissatisfied litigant and exposes himself to criticism. But if the stroke is inflicted by the law, it leaves no sense of individual injustice, and the losing party is not a victim who has been singled out. So maybe we should remember this quotation, and hopefully the members of our judiciary remember this quotation. This is the concern of the president about the way judgments are handed out from the court. Patrick Devlin there again says that if a judge leaves the law, can we have it back on? If a judge leaves the law and makes his own decision, even if in the substance that decision is just, the judge loses the protection of the law and sacrifices the appearance of impartiality, which is given by adherence to the law. That means if you adhere to the law as a judge, you do not appear impartial. The quotation goes on. He expresses himself personally to the dissatisfied litigant and exposes himself to criticism. But if the stroke is inflicted by the law, it leaves no sense of individual injustice. The losing party is not a victim who has been singled out. Lord Patrick Devlin, an English judge who made this comment. It's now 9:30, half an hour past 9 o'clock. We are going to 10 o'clock, and for the next part of the program, Lawyer Kufu will join us in the studio. Take your pen and paper and let's get some legal education, legal arguments going. Why did the court say what they said about law school? Why did the court say what they said about the Gitmo? And significantly for our business viewers, why did the court say what they said about the National Investment Bank and its obligation to honor a promissory note, a failure of which they were to pay over $100 million in debt? We advertised on Facebook earlier today also that we'll be showing you some archival material from Good Evening Ghana. So what are we doing? We're doing this at the second half of this year. We're deciding to go back to our 16-and-a-half-year history of producing and presenting this program to you for Metro TV. Thank you very much, all of you patrons who have been with us for that long, and for patrons who have been with us later and recently, just to share with you how we used to look, what we used to do, and what we used to say. Now, this program that we are showing to you was broadcast in 2003. What does that make it? 12 years ago. And it was on around the June 4th celebration. It was the second year of the boom speech that had been given at June 4th. My guests in the studio included Kweku Bako, Captain Soul, and Honorable Ben Kumbo. And yours truly was the host of the program. Let's see it. It's a 3.5-minute thriller. Here it is.
So June 4th has gone into the annals of history to join those days that later lost their significance as far as the holiday issue is concerned. The 24th February, the 13th January, and the June 4th, the 31st December. June 4th is no longer a holiday. But the NDC found occasion, or rather the June 4th movement found occasion to celebrate it. Last year they held a public lecture at which the famous or infamous boom speech was delivered. And this year they have also held a lecture. Former President Rawlings was at the lecture and he spoke. We'll be showing you excerpts of some of the things he said and we'll be discussing it. But more importantly, we are looking at the relevance of June 4th to our current political culture and our political life. My guest in the studio, Captain Joel Soul, who was not quite a member of the June 4th activities, but he was there. And also Mr. Kweku Bako, an authority on the relevance of June 4th and why June 4th came about. And in defense of June 4th, I'm sure Kweku should write a book titled In Defense of June 4th. And Dr. Ben Kumbo, a member of parliament, who this afternoon also delivered a lecture at the June 4th celebration, or the June 4th lecture organized by the June 4th movement. Gentlemen, you're welcome to the studio.
Thank you.
Assuming that the elections of 79 took place as they had been scheduled to do without the event of June 4th, 1979.
Well, again, we are in the realm of some hypothesis. Sometimes it's difficult to put your hand on certain things. But I can tell you, I fortunately have been in on the streets 4 or 5 years before June 4th. I also was a keen observer of the transition program. But there's one thing that happened with the elections, since we talked about elections. I tell you, the government, the military regime then, that is the AFRC, had no commitment as a corporate entity to any of the political contenders. And that helped a lot to make that particular election perhaps the fairest and the freest in Ghanaian history, because of the non-commitment of the AFRC as a corporate body. Of course, individually, some of them had their own commitments, and I know about all of them and where they stood and where they voted, because after the voting, some of us were together and we were teasing each other as to what the outcome would be. But as a corporate body,
I can hear the screams from your rooms. Hey, ah, oh, I can hear all that. We'll be doing this going forward. We have held on to at least 500 of our old programs, and we'll be sharing with you. We'll create a window for it on our Facebook page, Good Evening Ghana Archives, and when you're bored, perhaps you can go there and pick up 2004 We have significant interviews with today's politicians, some with President Akufo-Addo, some with opposition leaders, some with people who have passed, so we will not be able to show it, like Professor Mills and others. But we have some very interesting things. When our production team looked at it today, we're all screaming the way you are, A-R-O. And that's how it used to be. After the break, Kwame Kufu is our guest in the studio. He's come in his sartorial elegance and in his erudite presence. We join us to discuss law after the break.
When are we going to get these people out?
Telemundo presents a new telenovela, Iron Rose.
Are you the boss?
The story of a teenage girl who survives unspeakable act and becomes a woman who controls an empire.
Men should be used at your convenience and your desire, my love.
Don't try to use her to fill the void that was left by your real daughter.
That girl should not be named.
I'm extremely interested in finding out who's the woman that gave birth to me.
No woman is as strong as you are. What have they done to you?
I'm very intrigued by that tattoo. I remember seeing it 20 years ago on the men that abused me.
Beauty is her weapon. Power is her revenge. Iron Rose, 4 o'clock GMT. Repeat at 9 to 10 on Go TV.
Go TV. Live it. Love it.
لبيك اللهم لبيك لبيك لا شريك لك لبيك.
It's a journey of lifetime, a dream of every Muslim, a fulfillment of a religious obligation. Another Hajj season is here. Ghana's Hajj board has put together a package of $3,450 or 15,000 Ghana cedis for the benefit of every prospective pilgrim. Pay directly to the Hajj account at any Unibank branch across the country. Submit the pay-in slip to the offices of the Hajj board or to any accredited Hajj agent of your choice. When you get the call, you honor it. This advert is sponsored by Unibank Ghana.
Be a part of our daily programming for all major social media networks. Don't forget, we are big on your views. Share them on www.facebook.com/MetroTVGH. Follow our handle on Twitter at MetroTVGH. For news, hashtag MetroTVNews. For sports, hashtag MetroTVSports. And for entertainment, hashtag MetroTVShowbiz. Follow our post and join the Metro TV family on Instagram with handle MyMetroTV. And there's more. Find us on our YouTube channel anywhere in the world. It's Metro News and Metro Sports on YouTube, or you can WhatsApp us on 055-425-2525. Visit us on www.mymetrotv.tv. Metro TV, never a dull moment.
Oh yeah, oh yeah, oh yeah. It's a good morning. Wake up, wake up, wake up, wake up now. It's a brand new day. It's a brand new day. The tomorrow you're waiting for is today. Have a good morning, yeah. Just have a good morning.
Good morning.
Step out and make it happen.
It's the all-new Good Morning Ghana.
Have all you need to start your day.
This is Good Morning Ghana, live on Metro TV.
You can use.
He's made some interventions. We will follow up.
We're going to be talking some interesting issues. What is making news in our country today?
Good morning, Ghana. Good morning, Ghana.
What's up? up? My name is Kobe G Live. Now, the world is all about social media. Yes, social media. And it's my job to bring you all the entertainment that social media has to offer right here on Metro TV. So if it's about WhatsApp, YouTube, Instagram, or Twitter, you can be sure to find it right here on Click. Click, it's all about you and social media. So tell your friends, tell your followers that we go pop, bro.
I advocated very strongly that we should try and set up a political party which will promote the values of the PNDC. The PPA have been there, they have a tradition. The CPP have been there, they have a tradition. They have a network. We don't have any. So let us set up a network before we lift the ban.
So we basically had a transition and a new order based on 10 years of revolutionary experience and the adoption of a constitution which one could say was a kind of amalgamation of the parliamentary and presidential system, parliamentary system of the UK and the presidential system of America. Whether it sits well today or not is another matter.
When you see the full documentary, it will be our turn to give you a version of the 25 years of the National Democratic Congress, which is currently being celebrated. We will look at the position and image of Flight Lieutenant Rawlings, who virtually set up this party, or in whose name the party was set up to fight electoral fortunes in the 1992 elections up until now. Obviously, there's a bit of analysis going on about the conflict between Flight Lieutenant Rawlings on one hand and the people who just led the NDC in the last NDC government, President John Dramani Mahama on the other hand. In doing this, we have relied heavily on a book that was written many years ago. It was written by Dr. Kevin Shillington, and it was entitled Ghana and the Rawlings Factor. We'll go deep, we will spread out, and we'll look at the details of what the NDC formation is all about. You can't miss this documentary. It's coming up soon on Good Evening Ghana. Stay tuned.
We want for our people, through the elections, the presidential and parliamentary elections, it's not power, it's not a throne. We want nothing more than socio-economic justice.
Thank you very much for your time. Yes, our NDC documentary is coming up soon, and you should have a look at it. I'm already getting text messages, and those who can send us WhatsApp, do send us WhatsApp about this matter. Very, very sensitive, and it's also a matter that seems to have divided lawyers in terms of the opinions expressed by the court. Good evening, sir. Mr. Kufu, welcome to the studio. Thank you very much for your time. Social media is very excited that you're going to be speaking about this publicly. Let's start with the law school matter. So the essence of this is that people should take exams after a law degree before they are admitted to the Ghana School of Law. What does the Ghana School of Law do?
You have to put the question again. I don't understand you.
So we know that the issue at hand is that people should take exams before they get into the Ghana School of Law. What do they go to Ghana School of Law to achieve in relation to becoming a lawyer?
It's perhaps for the, I mean, much more importantly, is for the professional training as a law student. The law school teaches a lawyer or a law student, for that matter, how to attain the perfection and the standards towards the practice as a lawyer.
Okay, so that's why they need to go there.
That's it.
What did they used to be when you were a student?
In my days, the General Legal Counsel followed the law. You left the law faculty, you passed in the requisite subjects, and then you moved on to the law school. It was a seamless transition. Subsequently, when the numbers arose, or the numbers went beyond the seats available, I believe it was for such reasons that these issues, like independent examination board, interviews and examinations to be able to take away what they call the wheat from the chaff, arose. And these are the issues which have now come home for the chickens to roost. That's why we have this discussion today.
You agree with the Supreme Court's decision?
I have no quarrels about it at all. Basically, what was the Supreme Court doing? The Supreme Court's duty is to look at the law and to look at such an important matter because it affects everybody in the Republic. You have a situation where LI 1296, which regulates the conduct of the General Legal Counsel towards the education of law students, is operating side by side with administrative fiats. Now, these administrative fiats, illegal as they are, became so powerful that subsequently it eroded LI 1296. Because matters like an independent examination board, matters like the interviewing process, matters like the examination, were matters clearly not known to the law. And it's for such reason that the Supreme Court, in my view, rightly struck down these matters as being unconstitutional conduct. Because you see the poor, people who say this matter perhaps should have been in the High Court. I can't speak for the Supreme Court on that. There's a level of a judicial review attitude, the rationality on the part of the General Legal Counsel.
We'll come to the general public must understand what we are saying in terms of those who say they should have gone to the High Court, not the Supreme Court. But the important thing is a substantive matter. So this examination procedure has been going on for how long? Do you know?
I believe it's been going on for about 6-7 years.
Okay, where people are taking exams and getting
exams,
through. So the lawyers who have been called to the bar in the last 4 or 5 years have all gone through this process.
Absolutely, Paul.
Okay, and they've been called to the bar, and they are legitimate lawyers practicing law. So the Supreme Court is saying stop, because the point, as I'm picking up from the lawyers, is that Supreme Court pronounces the procedure to be unconstitutional.
Indeed.
Which parts of the Constitution would they have violated?
You're looking at a situation where a body set up under law, the General Legal Counsel, has assumed parliamentary or lawmaking powers unto itself. That is where you will discern the unconstitutionality, when the General Legal Counsel decides to assume lawmaking powers. For example, the interviewing process is not known to law. You look also at the issue of the independent examination body is not known to law. The interviewing process is not known to law. The issue of the examinations itself, which are taken subsequently after the completion of the LLB, were all matters known not to law. And these were matters regulating the conduct of a professional association.
When you say it's not known to law, that the General Legal Counsel cannot do it.
Yes.
If the General Legal Counsel wants to do that, how should they get it done? They should go tell the Supreme Court?
No. The General Legal Counsel acts as a body set up by law. And to that extent, therefore, it must act in accordance with law. Every step taken by the General Legal Counsel should be in accordance with the strict doctrines of the law. And this is a situation where the General Legal Counsel stepped outside the law for purposes of admitting people to study a serious profession like the law. You will discern clearly that all the matters that they put out there, because Paul, you have to look at it this way. Lawyers in this country are trained under the general, by the training of lawyers is regulated by the General Legal Counsel. Act 32, the Legal Profession Act, admits and then regulates the conduct of these lawyers. You will then see that the training of these lawyers is then eroded by these interventions, which are completely illegal. These interventions are the examination board, these interventions are the examination and the interview. That is the essence of the unconstitutionality.
So you need Parliament to pass laws to do that? Are these not administrative matters simply that the General Legal Counsel should be able to admit and to be able to procure?
You have an LI 1296. It's important for people to know the standards that they have to meet. It's very important, because every
Does the LI say how people should get out from LLB to become lawyers?
The LI 1296 basically sets out the number of subjects that you have to pass.
Oh, I see. That's
courses
interesting.
that you have to do.
Pass from the LLB.
Pass from the LLB.
And then when you come to law school,
people, for example, who didn't pass certain subjects in my time, who had to rewrite certain subjects in order to make the requisite qualification to come to law school. Now, what has happened is that the persons regulating legal education had moved far beyond the purview of LI 1296 and had instituted their own mechanism. So this was a law upon itself unto a law, which was clearly unconstitutional, clearly unsupportable, unwarranted for that matter.
Well, I have a text here from a lawyer. He says, this was a pure administrative law matter. There's no constitutional issue here. Laymen understand unconstitutionality to be the breach of something in the 1992 Constitution. Did the Supreme Court find a breach in the 1992 Constitution?
Well, two things. When I heard about the decision initially, I must have thought that perhaps the court was looking at the issues that if this matter got stuck in the High Court and traveled all the way through to the Court of Appeal and then to the Supreme Court, much more damage would be done to students than it intervening and picking up the matter as a constitutional matter. That's one thing that...
Are they able to do that?
Well, you see, for example, you remember the Woyome case?
Alfred Woyome, yeah.
While an appeal was pending against the decision of the High Court, the Supreme Court reached into the bowels of the Woyome case and pulled it up as unconstitutional judgment and short-circuited the process.
For speed?
For speed.
Can they do that?
Well,
is that not the behavior of an octopus?
You may call it an octopus. Sometimes you have to look at the beneficial aspect of that particular decision. To my learned friend who speaks this language, I salute him. I respect that kind of thing. But we have to ask ourselves this. If the matter had gone to the High Court, and the High Court had ruled against the General Legal Counsel, perhaps there might have been an appeal. Students will still be walking through this untidy process. Then it comes to the Court of Appeal. and then the record is put together, we will be doing 2, 3, 4 years. For example, the NIB case was filed in 2010. It's in 2017 that it has gotten to the Supreme Court. That's been 7 years. Okay. Lawyers will tell you that most cases that start in the High Court end up in the Supreme Court between 5 to 7 years. It's a constant. It's a constant. So perhaps the Supreme Court, at the back of its mind, while it is not expressed in print, took the policy rationale that let us take this case, assume jurisdiction, and let the society have the beneficial effect of our decision. Because at the end of the day, you have to look at the substance which emits from the decision. Should we rather have waited for 7 years before the decision was handed down, or the Supreme Court looks at it on the constitutional side? For me, the unconstitutionality is that the General Legal Council became a parliamentary law-making body. And for me, that is clearly an usurpation of the constitutional powers given to Parliament under the Constitution. That's why I see it from.
So what the court is saying is that what the General Legal Council did to amend the procedure by which people became lawyers, or by which people were admitted to the law school, was a matter for Parliament.
Absolutely.
I see.
Absolutely.
The Parliament should have amended the law that set up the General Legal Council.
They have to
include examinations and all that.
That is true. You see, the point is, nothing stops the General Legal Council from going back. Nothing stops the General Legal Council from going back to Parliament and putting these regulations down. If Parliament passes it, so be it. But the fear then again is that most parliamentarians are now reading law. Most people are reading law in the society now. And most people detest examinations after you've done the LLB. So I suspect that any attempt to amend the regulations will not find succor or warmth in Parliament House. And that's why perhaps the people running the General Legal Council decided to go through the back door to assume the powers of Parliament. And that's what the unconstitutionality is. You have to remove the facade. And when you remove the facade, you will see there the unconstitutionality. Why didn't they go to Parliament for Parliament to make the law? They took it upon themselves to make administrative fiats which have regulated the conduct of citizens when they had no right so to do. Therein lies the unconstitutionality.
It's an interesting dimension that you are introducing, that perhaps people as parliamentarians and general public would not like the examination procedure. Has there been some chaotic outcomes of this in this examination procedure? Have many people failed, something like that?
I regret to say so. Many people have not been able to make it. Many people did very well with their LLB degrees, went on to write the examination, they did not pass. Some of them had to fall out, they were stuck with the LLB. But then again, it's not everybody who does the LLB who becomes a lawyer. I can understand the confusion with the General Legal Council went, but that is not pardonable. The numbers suddenly increased. You realize that, for example, after the 2012 election petition, everybody became interested in the law. And most people after their first degree wanted to read law, not perhaps for purposes of even trying to practice the law, but to have a knowledge of the law, because every contribution today is based on the law, the Constitution. If you've not read the law or have some knowledge of the law, it's difficult for you to contribute in positive direction. So these are the matters. So the numbers came up, but you have to do it by law.
So let's get to the unconstitutionality matter. So the Supreme Court says a matter is unconstitutional.
Yes.
And then they say that you can, however, undertake this unconstitutionality in September 2017. Months after we have said it's unconstitutional, you can do that. Take the exam in September 2017. But don't do it in 2018. If it's unconstitutional, it's unconstitutional. It should end in June, the day the judgment is given. The day a court pronounces an unconstitutionality, there goes, it's unconstitutional. I was just talking about Justice Philip-Archer in the 31st December case. The court pronounced on 28th of December that 3 days later, 31st December is unconstitutional. They could have said, do it now, but don't do it. They said, no, it's gone. You can't do it. Even when the government had laid a timetable for it, budget has been approved for it. The court, in pronouncing it as unconstitutional, said it's gone. Where from this unconstitutionality, but carry on?
There's a big, huge distinction between the 31st December, where soldiers were asked to march and go home subsequently, interspersed with speeches of revolutionary fervor by J.J. Rawlings in those days. Huge difference. You have here a group of students who have left the LLB program and are now preparing for the examination. You have a qualified or requisite number of seats vis-a-vis the students who far surpass the number of seats. So you have this issue or the zone which is called temporary invalidity. Now, under the temporary invalidity doctrine,
temporary invalidity,
yes,
temporal,
temporal,
it's
yes,
invalid, but it's
yes, exactly. Okay. You may have to look beyond that unconstitutionality you speak about to avoid chaos. And this is not the first time the court has done that. You must remember the Ejefrimpong case. I recall that some person, a lawyer, went to the court and spoke about Article 15, the dignity of the individual, and said that people, the conservancy laborers, could no longer carry, human excreta on their heads. The Supreme Court ruled that that was correct, and that every household in Accra should have a proper toilet facility in the house. But then they suspended it for 5 years.
Why?
Because it was not possible from the date of the judgment to ensure that every household could comply. So they asked the Accra Metropolitan Authority to take steps to make sure that people came into compliance with that particular mood. It was not possible to leave the courtroom and to find the house of Choco with requisite health facilities in terms of what happens immediately. It was not possible. So the AMA case is a clear indicator that the court, depending on the facts, will halt immediately or suspend or allow a temporary invalidity period. And this is one of the situations. You will see from Justice Badegbe's judgment that he speaks and gives examples from foreign jurisdictions. There are situations. I recall that there's a situation. Let's give an example, which is with us at home. The bail situation.
Bail?
Yes.
Which bail?
For example, they said that every crime in this country was bailable.
The bail,
yes.
Yes.
The court didn't go back and say, for all the people who were refused bail on Section 96(7), admit them to bail. Did the court do that?
No.
They were still in custody, having been refused bail.
Even though it was said to be unconstitutional?
Absolutely, because those were accrued rights under the existing position then. The court couldn't go back because it will lead to chaos.
Okay, so you think that the unconstitutionality is not controversial. The unconstitutionality which the court, however, says continue in September is not awkward.
It's not
so
awkward.
The candidates are going to submit themselves in the exam in September.
That's correct.
And all the demerits, quote and unquote demerits of the process will be with them.
True.
Even though the court has ruled that they ought not suffer those demerits.
True, Paul.
That's awkward.
It's not awkward. You have to look at the system because the facts
their rights are being violated.
The facts that come, the facts that come to a court are not perfect facts that are scripted from a Bible. These are a unique set of facts. Paul, you say to me that you want to have all the students go over and then nobody writes an exam.
If that's what the court says,
there are no facilities to train them. Then
well,
you put,
but eventually we'll get there.
No,
that's where the court is taking us.
The court wants to take us into 2018 when requisite preparation has been made for students to be trained.
Can we in 1 year get the facilities to train them?
Well, we should be able to, and that's why the General Legal Council, basically this decision will still come back to the quota system because I can foresee the faculties now taking people on the basis of a quota system.
Well, there's also fear from private sector who have produced universities that are training lawyers.
Yes.
They are worried that this probably is targeted at them. So that eventually Parliament will not amend it. It comes to the quota system, and it will be going in a certain order, University of Ghana, University of Science and Technology. So if you're a private institution set up and committed to train lawyers, your people will not come to your school because they know that your quota system to the law school is 5%. And it's unlikely that they will get in. So they are also expressing those sentiments.
The practice of the law is not a mass cuckoo spraying exercise. The profession is not a mass cuckoo spraying exercise.
But they keep telling us we don't have enough lawyers in Ghana.
Well, I don't think so.
Well, the Attorney General's office doesn't have enough lawyers.
The point is this.
We've heard that so many times.
We need to have lawyers who are properly trained. It's not a mass cuckoo spraying exercise, Paul. We can't afford it. We need to train lawyers up to requisite standards. You say to me that perhaps you rebuke this temporary validity argument. But then again, are we going to have all these students just jump in and then move into the system? You don't have enough lectures to take all of them because it was not foreseeable that this will happen in 2017. So you have students who are put out there and come onto the unsuspecting public rendering improper advice.
So in 2018, assuming Parliament doesn't do anything about the examination process or doesn't deliver any intervening process between LLB and the law degree and studying to practice as a lawyer, assuming Parliament is not able to deliver that, then in 2018, you will have all those people who failed the exams qualified to go to the law school. So you're dealing with significant numbers.
The point is this. I can foresee some collaboration between the faculties and the General Legal Council.
Upon the quota system?
Upon the quota system.
Which will go against private schools that are setting up
They're going to make sure that people who qualify through the LLB are also well sieved. Because to get to the law school now, you may then have to have a very strong and proper LLB.
There's another argument, which is the last one before we go today. The Ghana Association of American Trained Lawyers, they are watching us on Facebook now. Now, in their country, there's nothing like a law school.
Right.
You take your LLB, as you know, and then you go and take an exam to be called to the bar of one state, New York, New Jersey, wherever, they are thinking that perhaps we should be thinking about that as an option as well. People should take an exam that is designed by the General Legal Council. Bar Association participates in it. Those who pass the exams are called to the Ghana Bar. And then they can arrange, once you are called to the Ghana Bar, some form of pupillage that will properly train lawyers in the law chambers, which apparently pupillage is dying these days because people leave law school and they set up law firms and all of that. So they are saying that. Do you have a view on that?
Well, it's an alternative argument that you leave the LLB and then you go and write an exam. And then subsequently you have to intend to learn the tools.
Yes, absolutely.
Unfortunately,
intend for a year, they say.
Our system, even with the internship which has just been introduced, is not sufficiently strong.
Why?
Because I don't even know how you mark the students who are interning.
You, the lawyers, the senior lawyers, will mark your intern.
Honestly speaking, I've not seen regulatory guidelines as to how to mark the interns. I've not seen one being passed.
Well, they can produce one. So you tick the boxes for the intern.
Well,
attendance, speed, smartness.
I'm saying to you, for example, Paul, that even the number of law firms we have in the Republic that can take interns are not that many. They are not that many.
I see.
So this internship system, which may be useful for the American society where you have a lot of firms, is completely, it's not be something which will be proper for the system. And Paul, keep one thing in mind. Even in England, only a few people are able to get spaces for pupillage in law firms.
Yeah, that's in England.
Yes,
but
even
in America
England,
they do.
And America is not different. If they say otherwise, it's not different. The law practice, the law profession has always been like a sieve.
Okay, let me acknowledge Kwekubu Afwajiman and his group who are watching us on Facebook from the United States. He sends a question. By the way, he says to thank your family because your father taught him government in A-level, and he's quite grateful for that. He's an attorney practicing in New York and New Jersey. Kweku says that they do the JD from the law school. I'm not so sure, Kweku, what you mean by that. If you can come back on it, if you're still on the program when you do, I will be able to respond. Okay, but let's move on, Mr. Ekufu. Gitmo 2. The court said, again, unconstitutional, go back to Parliament. It looks like on that day, Parliament was very favorable in the eyes of the court. Atuguba says no, President Mahama was right. What's your view on that?
I disagree with the court.
So you agree with Atuguba?
I may agree with Atuguba's Justice Atuguba's conclusion, but not the path towards his conclusion. I have a very different view of the matter. And it's a very fundamental, understandable point that I take. These are two men who were not convicted felons, are being tainted persons, in the sense that they had been kept in Guantanamo Bay. So these are tainted people. We have to ask ourselves the question, if these men had been released onto the streets of New York and applied through the Ghana mission or the Ghana embassy in New York to come to Ghana on a visa basis, would the president have had to go to Parliament or immigration, go to Parliament to get permission to give them a visa? The answer is no.
But the application of visa doesn't go to the president, does it?
I'm just saying the executive arm. I'm just giving an example. Now, the only difference here is that their visa application was made on their behalf by a state.
The United States.
The United States. But does the mere fact that the visa application is made on behalf of an individual a matter for ratification by our Parliament? Certainly our Parliament must have...
Is that how they came in, by visas?
It is a note verbal. They were allowed entry into the Republic. I use the word visa in terms of permission to enter.
Okay.
So they were allowed...
Not a regular visa.
Yes, they were allowed entry. Yes, they were allowed
passe.
entry to enter into this Republic on the basis of an application by the United States government. Paul, absent the application, would these people have been required to have the applications put before Parliament? I say no to that. And then there's a thing about laws that I know from basic jurisprudence. You don't go to Parliament to pass a law for two people.
I don't get it.
Parliament is going to pass a law for Bin Atef and the other gentleman, I don't recall his name.
Yeah.
But that's what Parliament is going to do. Laws should have general application. It will have been an entirely different thing if the US authorities had said to the Ghanaian authorities, we're releasing 10 or 20 people from Guantanamo Bay and want to send them to Ghana. In the Ghana Parliament sits and says, okay, we're passing a law which says that the US government is desirous of releasing these people and that certain people will be brought to Ghana. And that these are the conditions under which if you want to come to Ghana from Guantanamo Bay must be met or must be ticked. That will be law.
But if it's two, it's still the same.
No, Paul,
we don't know whether the United States government will come
No, you do not make a law for the exception.
Two
is an exception. You must make a law for the general. Our lessons in jurisprudence show us that you make a law for the general, and if there's an exception, you caveat it in the law. But you don't make an exception as the law. Paul, for example, if the DVLA found out that we have driving license but we have disabilities and we should not have been given driving licenses. Are they going to go to Parliament and make a law and say Adom-Otchere and Kwame Kufu should not drive? No. They will make a law and say, however, persons with such disabilities cannot drive. Because that's the basic principle of law. You make laws in general, you don't make laws as an exception.
Was the court more concerned about making an actual law or about getting Parliament in the process of the final decision making?
I say to you, and very respectfully to the court, that there's no compelling constitutional reason why in such an executive manner, or executive matter, to put it properly, Parliament should have a stake in it. It's always been the case that in immigration matters, the courts have always stayed back and left the executive to run it. Yesterday, Donald Trump's travel ban received some favorable edicts from the U.S. Supreme Court because the court recognizes the power of the executive to deal, albeit freely, on the international plane with who can enter the republic or the country. So Donald Trump's case itself yesterday by the U.S. Supreme Court, 9-0 unanimous decision, they'll consider arguments fully in October, clearly tells you that when it comes to immigration matters, the executive is rather best left to deal with these matters. You have to answer the question, and all of us will have to answer the question. I know from the learning into for an attorney general that Parliament is master of its own procedure. To hear the Supreme Court say that they've given Parliament 3 months to do something confused me. The Parliament
was it an order on Parliament?
It was an order that you have to do it within 3 months.
The violation of separation of powers?
Well, you may have to ask them. These are matters that we have to discuss as we proceed. I offer no answers, I offer no finality. I just raise the questions that the court now asks Parliament to do something within 3 months. Now, secondly, Paul, in the event that Parliament does not approve and we have to return these men, these are not men who are citizens of the United States. At the time that they were brought into the Republic, the United States had taken the position that they will be here for 2 years. Now, what we're doing now is that on the international plane, the Republic is now pleading inconsistencies because we give the impression to the Americans that all was well. And subsequently, we now come back and say all is not well. Remember that state has also taken its national security measures with respect to these people. If in 3 months Parliament does not pass this requisite ratification, as the courts will say, and we seek to return them, and the U.S. Supreme Court says no, we will not have, the U.S. government says no, we will not have them, what do we do?
That's interesting.
Absolutely. The court must not put itself in a situation where it will make orders which are not enforceable.
You're talking like Philip Archer then, in 31st December.
Well, I don't know whether I'm talking like Philip Archer. I was there when the case was argued. I was young. I was in my first year.
Well, he said the courts, put itself in the position because the court didn't have armored vehicles to protect.
No, but that was a completely different I speak of the situation.
But that's
because you see, to enter American airspace, the Americans will have to agree.
But they have a country, don't they? Benatef, where do they come from? Don't they come from Syria or something?
They come from Yemen.
Yemen.
Now, Yemen now is a country stricken by cholera and war. I do not know which plane is going to leave this republic to land in Yemen.
British Airways will go there.
It will not go there.
KLM won't go
Nobody will go there. People, the infections there for cholera is like 5,000 a day now.
In Yemen?
In Yemen, because the Saudi Arabians have invaded. That's where these people are from. Now, their last port of call before they came here was the United States. They are not destined to go back from this republic. Donald Trump says, no, I'm not having them. Because you are stopped from changing your position. And these
yes, with the context of international relations.
Absolutely, you are stopped. So these people don't leave Ghana. Who is going to be held in contempt? So we have a Supreme Court decision which is not enforceable. These are some of the things we should be looking at.
I have a text message here from somebody that you know, a gentleman. He says, Paul, please kindly send me Lawyer Kwame Kufu's number. He's very good. Okay, so that's
thank you.
Compliments for you.
But that's the point.
Okay.
We have to look at these matters critically. And I just pray that the Attorney General will go back to the court for a review.
Of this matter?
Yes, they say to me it's a 6-1. But the courts are not stagnant.
It's heavy.
It's heavy. But the courts are not stagnant. The courts move. Because we have to ask ourselves the utility value of the decision they have given. How enforceable is the decision? Parliament has a schedule. They told us in Tufu Attorney General. They told us in GHMS as well. The Parliament is master of its own procedure and time. Suddenly, we have the Supreme Court telling Parliament, do this within 3 months. Separation of powers, Nixon versus Sirika. You've got all these things coming up.
Well, it's a scratch on against the principle of separation of powers.
It may be a scratch.
Maybe. But it looks like
But look at the enforceability. Look at the issue of the president admits people into the republic on the basis of an executive conversation he has had with his counterpart presidents. And you say to me that the president should go to parliament to get a ratification of 2 people. If you look at the isotophone case, you look at the Balkans case, the court was talking about major agreements and minor agreements. And the minor agreements do not go before parliament. You look at Article 268,
Somebody can talk about the tax, the issue about state funds being applied for these 2 persons, that the president does not have power to spend state money in this context without consulting parliament.
We have no evidence that state money is being spent on them.
Well, President Mahama says America did not give any money for it.
Well, I do not know about that.
But if there's not state
money...
There
have been very inconsistent statements on this matter.
Yeah, but if it's not state money, who's spending?
Paul, these were not matters in evidence before the court.
It wasn't, yes.
Yes, I like to speak to the law.
Yeah, but could that not be a reason
why... Well, I'm not going
why
to go according to political wind vein.
Yeah, but if the court is thinking like that at the back of his mind...
The court cannot be thinking about... If the court wants to address that issue, it must call up arguments and then speak to it, and then we all know what you're talking about. But these are not matters there, so I don't like to get into the...
But you haven't seen the full judgment of all the 6, have you?
The full judgment of
all the 6 judges who ruled in favor of this. No, I haven't seen it either.
Because it's not yet been certified. But be that as it may, we have the import of the decision. And I say to you that the enforceability aspect is there, the separation of powers aspect is there. The issue as to whether the court can direct the executive as to who should be allowed. We have to keep in mind that learning has been introduced yesterday, which reaffirms what happens in Commonwealth nations in the Donald Trump travel ban situation.
That's interesting.
And it's very important. The executive must be left to administer who comes into the republic, and then the court will supervise. But the court does not direct the executive.
Just before we go to NIB, we have a very short time to finish this program. What is your point of departure from Justice Atuguba anyway?
Atuguba spoke of the aliens. I've not read his full decision, but he spoke of aliens, and that when the aliens are found, refugees are found in the country, they didn't come to the country as refugees. So that's why I depart from him. But the critical thing for me is this. I agree with his conclusion that these people, the president had the executive authority, because the Constitution, Paul, if you look at Article 75, ratification of agreements, are these the agreements anticipated by the Constitution? We have to ask ourselves that question, to go to Parliament. Are these the kind of agreements? Parliament will be overburdened, so that every time the president reaches an agreement, he goes to Guinea, and then Guinea says, well, we are going to come here and do something. Our investors are going to come here. President has to come back and say, you know, I spoke to the Guinea president and we have to do this. Parliament will be totally overburdened.
There's another consideration that it could have been a national security matter, and the President Mahama could have carved it under national security matter. In fact, any president could have said this is a national security matter. He didn't need to discuss anything with Parliament. Some people who are against the Supreme Court ruling are saying that it can be construed as a national security matter.
But these arguments were made last year. These arguments were made last year, but that is not my point of concern. Point of concern is that the executive has almost absolute authority with respect to who can be allowed to enter the country. That's the executive arm. The courts should be slow to intervene or to interfere in that, especially on the facts of this case. We are going to Parliament to pass a law for 2 persons.
The National Investment Bank
is
no longer going to pay some money that the High Court and the Court of Appeal thought they should pay, over $100 million. This was the ruling of the Supreme Court. It's created some, it has unnerved a lot of people in the finance banking sector. What was your view of the Supreme Court ruling in this one?
It's a very simple thing. People speak about the fact that a promissory note can change hands. It can change hands immediately that the note is signed. I know.
Yeah.
And therefore the identity of, but the rules, the procedural matters to achieving substantive justice requires a party to disclose its capacity. A party that does not disclose its capacity and therefore has no capacity in the face of the court is almost as naked as the wind.
Okay, so you are referring to the part of the court's ruling that said that the NIB does not owe because the people who brought the matter before the court lacked capacity.
I think that the part about NIB does not owe was arbiter.
Not that they don't owe, but they are not obliged to pay this money.
Well, I don't think that it's even, I think the court...
So what do you think is a germane matter?
The germane matter is about the capacity. Because when the court says that your capacity is defective, it does not even address the merits of the matter.
That is whether you can come to court or not.
Whether you can come to court or not. On every occasion that the issue of capacity has come up in the law, capacity has been dealt with at first point in time, and if the capacity is found to be deficit or crippled, that's the end of your case. So the latter statement that the NIB is not obliged to pay, we're just merely gloss on the polish.
So you agree with the court that on capacity, so really the court was saying there was no cause of action. Is that what that's a different matter?
No, this is a different matter. Paul, the rules require that a foreign party appearing before our courts should disclose its identity and have endorsed its address. This is quite interesting because the court now construes that particular provision to be mandatory. The court's learning on mandatory and what is permissible has changed consistently under Order 81 since we had the new rules. There are times that it is permissible. There are some times that the courts surprisingly will say, oh, this is mandatory. So lawyers, scholars have been a bit confused about as to what is mandatory and permissible. If you look at the Nawus versus Ghana Commercial Bank case, this is exactly the situation that took place. And the court said the failure of the address rendered the writ invalid. So to that extent, therefore, despite the confusion sometimes in what is mandatory and permissible, the court was following authority. You may ask yourself whether the court at the back of its mind was trying to stem the judgment debt that we've been suffering and quickly latched onto this because of the value of the money, because it is not in dispute that NIB has received the money.
But this defect can be cured easily by returning to the court and disclosing proper capacity. And will that change the situation that NIB must now pay?
Justice Benning says to you that the issue of amendments cannot rise after the writ has been issued, because it must be done before the writ itself leaves your law firm.
So it's fatal?
It's fatal. To him, it's incurable.
Oh, really?
Yes. He says to you, these are not one of the things that you can change midstream, because it's so defective. It's
just going to put my address there. My address wasn't there. I want to put it there.
It's not a writ without the address.
Yes, but so
there are examples, for example.
So can they, however, start the process in the High Court once again, all over again?
Statute of limitations, Paul. It was a simple contract.
Oh, it's gone?
It's gone.
How many years?
6 years.
What's the statute of limitations?
6 years contract.
And it's gone beyond 6 years?
Yes.
So, oh, I see. But that's worrying.
Yeah.
What about the Supreme Court review?
The Supreme Court review, I have my doubts. This is a court that spoke with one voice, judgment written.
This was unanimous?
This was unanimous. Written by Justice Benning, 7.
7-0?
7-0.
On capacity?
On capacity. In this capacity issue, Paul, you go through the forest of judgments that we've had, and on every single occasion that the capacity comes up, you will notice clearly that capacity is a very serious matter. Once it is struck out, it's gone.
Okay. That's interesting. A lot of people saying that you're doing well and they're enjoying the program. 14 minutes past 10 o'clock. Thank you very much for your time. We'll be wrapping up shortly with Mr. Kwame Kufu. What do you do these days, Mr. Kufu? I'm asking that because your social media supporters were earnestly and urgently hoping to hear your name mentioned as a Minister of State, Deputy Minister of State, something around the Office of the Attorney General, knowing that you had worked in the President's law firm and that you are a part of the election petition lawyers. It was expected that you would be serving in government to assist Nana Akufo-Addo, whom you had supported publicly on social media all the way to voting day. What are we doing these days?
Paul, the point is this. Not all of us can be in government. Everybody has a role to play. I prefer to practice my law. I am not ready to be in public service at this point in time. So I'm happy to practice and do what I do. We still continue to support.
Will you get into public
sometime in the future? But for now, I'm happy practicing my law.
You also have some supporters in the mountain in the Kropon where you come from. Are you thinking about that seat after Dokia has done it? Are you thinking about the Kropon seat for the NPP?
These are matters for another day. But I'm very happy doing what I do now.
But you are excited that Akufo-Addo is president eventually?
Absolutely. This was a matter I believed in. It was a project I believed in. Akufo-Addo's presidency tells us it killed that tag that a man is arrogant and a man cannot do well in this republic. So Akufo-Addo's ascendancy for me was something that has opened the doors for every child who is confident to stand up there and say, vote for me. It's a huge thing for many good-minded people.
The victory and the success of Akufo-Addo.
Absolutely.
It represents a lot within the Ghanaian society.
Absolutely, and beyond. We look forward to it from the very moment I came to work with the man. And it's come to pass.
How many years ago was this?
I came to work with him in 1998. I served for 19 years. I just left in May.
And as soon as you went to work with him, you thought he should be president?
I believed in him before I went there. I still believe in him.
Good luck, Mr. Kufu. Thank you so much for coming.
Thank you for having me.
It's a pleasure.
Absolutely.
And thank you, viewers, for watching. I'm sure that you've enjoyed the program. Thanks for watching and good night.